Hi, I'm Martin. Welcome to the second video on automated decision making and profiling. If you didn't see the first video, I encourage you to look at it because it's a great introduction to the topic. See the link below in the description. In this video, we'll be discussing the new rules to be respected by data controllers and the new rights granted by the GDPR to individual citizens. And all of this in relation to the automated decision-making and profiling, of course. In the first video, we showed just how far-reaching and impactful the consequences of online automated decision-making and profiling can be on your everyday life. Being discriminated from certain vital services like financial services, being manipulated to act in a certain way, vote for a certain politician, or buy a certain product. So how can citizens protect themselves? So the General Data Protection Regulation sets obligations on controllers and grants EU citizens certain rights. The controllers, the companies that are handling your data, have to ensure transparency, data minimization, accuracy, legal basis for processing, and storage limitation. But we'll go through all of these individually. Transparency is pretty straightforward. It's just informing you about automated decision-making and profiling. It probably will look like something you're familiar with, like pop-up boxes or terms of service notifications, things like this. Data minimization is also easy. It's just using only the data that is strictly necessary to carry out the service that you're using. The accuracy requirement just means that there should be no mistakes in the data gathered by these services, because otherwise it might skew the automated decision-making or profiling. But of course, it's really problematic because we all know that we post plenty of inaccurate things about ourselves online, like taking a selfie in front of a very expensive sports car which we don't own, or photoshopping, for instance, ourselves on top of Mount Everest. So of course the aim is not to force everyone to post only truthful things about themselves online. That should be anyone's right to post whatever they want, but it's really hard then to make sure that accuracy, this requirement, is respected. And the requirement, which is really important, is that they should have a legal basis for processing your data, for carrying out automated decision-making, or for profiling. And since, as you'll see, the reasons for having that legal basis are quite vague, it really opens the door for using your data in ways which you might not expect. So some of these reasons include having your explicit consent, when it's necessary for the performance of the contract. So for instance, if you buy something online, they require your home address to know where the good has to be delivered. The necessity to comply with certain legal obligations, like for instance, in case of fraud or money laundering. The necessity to protect certain vital interests. An example could be, for instance, monitoring the spread of a viral disease. And the last one is for the pursuit of legitimate interests of the controller. And this last one is really tricky because there's no real clear definition of what a legitimate interest is. The GDPR simply states that whatever those legitimate interests are, they have to be balanced with your own legitimate interests, your own fundamental rights and freedom. So just like many provisions of the GDPR, all this will probably have to be clarified in court and settled case by case. Then there's storage limitation, which means that the data should be kept only as long as is strictly necessary, but that of course is also very hard to verify. Just think of yourself and how easy it is for you to keep copies of data. So I hope you got all that checklist, and now we're going to move on to the next section. Let's now see what rights are granted to you by the GDPR. And your rights include the right to information, the right to access, the right to rectification and erasure, the right to object to use of your data, and restrictions on processing. The right to information, or the right to be informed about automated decision-making made by an algorithm using your data. And that right simply mirrors the obligation on controllers of transparency.
All your data belong to us.
The right to access. So going beyond information, you have the right to access the data that is being used. And also you have the right to know in which way the automated decisions or profiling was made.
It's a complex form of statistically significant correlations derived from your data run through a neural network.
The right to rectification and erasure gives you the right to correct any inaccuracies in the data or to simply erase certain data.
Here is all the data from the past 2 years about your mouse input and clicks, your geolocation, your search terms, the websites you visited, how long you stayed. Please correct anything that's inaccurate.
The right to object. You can object to the processing of your data on personal grounds. So far, there's no clear way on how to exercise that right, and the controller can override that right for compelling reasons. And since there's no clear definition, it's up to member states on how they're going to transpose it and how courts are going to apply it. However, there is one right to object which cannot be overridden, and that is objecting to the use of your data for advertising. Normally, this should be as easy as going to whatever services you're using, finding the settings, finding advertising, and then ticking a box that says, I don't want you to use my personal data to show me ads. So you'll still see ads, but they just won't be targeted based on your data. Then there's the right to restrict processing. So instead of erasing or correcting data, which can be quite tricky and nobody really knows how to do it, as you've seen in the previous sketch, you also have the right to force a profiling or decision-making algorithm to ignore certain data in the way that it's working. Just ignore this data. Finally, there are the rights that concern automated decisions and profiling, which can have legal implications for you. And these will require an actual person, a physical person, to review the decisions that are being made. Now, the examples for legal effects include the denial of certain social benefits like housing benefits or child benefits, refusal of admission to a country, a decision which affects your financial situation, like being denied a loan, a decision which affects your access to healthcare, like being denied health insurance, a decision affecting your education, like being denied access to university, a decision linked to employment, like a fully automated recruitment process. And at the same time, there are exceptions, of course, which allow for the automated decision-making process. If it's necessary for the performance of the contract, if it's authorized by EU law or member states law, and if it's based on explicit consent. In any case, the controller should obtain ways for you to get a person to manually review the automated decision-making process. And also ways for you to express your point of view or contest the automated decisions that are being made. And it's also unclear how this is going to work in practice. Point is, it's really hard to make sure that a human manual decision has been made correctly. Also, customers are not always in a good position to negotiate or to take advantage of these new rights. So in summary, these rights and obligations are definitely a step up from what it was before, but there's still no clear indication on the loopholes, how they're going to be closed, and a lot of questions unanswered as to how this will be implemented in practice. In the next video, we'll conclude the topic and see how automated decisions can be used in the best interest of citizens and also how the GDPR could be improved. See you next time! That cool?
Yeah, that was good. It's super exciting what you're talking about.